I'll hear from you, Mr. January.
Justice Madlanga, I apologize for the delay. I had some trouble connecting, but I do believe we are all sorted now.
Thank you very much. Thank you, Justice Theron. Yes, Mr. January.
Good morning. I am the Registrar Clerk for this hearing. Justices of the Constitutional Court, all counsel are online. I call the matter of Willem Grobler and Clara Phillips for hearing. Counsel are now advised to place themselves on record. Please note that this hearing is being recorded.
Yes, Mr. Force.
May it please the court, I appear on behalf of Mr. Grobler, the applicant. My name is Wesley Force and I'm instructed by Miller Bosman Leroux.
Thank you, Mr. Force. Yes, Mr. Fagan.
May it please the court, my learned friend, Mr. Morrissey, and I appear on behalf of the first respondent.
Thank you. Yes, Mr. Force.
Thank you. This application concerns the competing interests of Mr. Grobler and Mrs. Phillips with regard to a property situated at 59 Dummer Street in Somerset West.
Justice Madlanga, I'm really sorry to interrupt you. The legal representative from the Stellenbosch Law Clinic had not yet been admitted. They have just been admitted and they are joining now.
Oh, thank you, Justice Theron. Thank you very much.
I see them on the screen.
Yes.
Thank you.
Thank you very much. Thanks, Justice Theron. Yes, Mr. Force.
Thank you. The property at 59 Dummer Street in Somerset West is owned by Mr. Grobler. That is common cause. It is also common cause that Ms. Phillips is an unlawful occupier of that property. There are two key questions that arise in this matter for determination. The first question I submit is, would it be just and equitable as envisaged in terms of section 4(7) of PI to order Ms. Phillips to relocate from 59 Dummer Street in Somerset West to other suitable accommodation also in Somerset West that has been offered by Mr. Grobler? That is the first question. The second question that I submit arises for consideration is
Mr. Force, on the first question, the relocation to another property, is that not only on the table, depending on whether or not there's something before us? The first respondent takes the point that that offer was no longer on the table. Or are you saying that on the basis that the offer has now since been made and it is still on the table before us as it was before the SCA? But the first respondent says, no, not at that late stage. It wasn't there before the magistrate, it was a straight eviction. So when you say relocation to another, is that on the basis of what the applicant, Mr. Grobler, is offering now? Because you then also have to grapple with the point made by the first respondent that, but we cannot look at this at this late stage. It was never there before. So in a sense, I guess the point is, even in the exercise of the section 4(7) discretion by the magistrate, that's not something that was on the table at all. How do we deal with that? But anyway, continue.
Yes, thank you. Perhaps I can deal with that. I submit the answer to the question is twofold. First, prior to the litigation being commenced in the Magistrates Court, Mr. Grobler approached Ms. Phillips on 3 occasions, and he engaged with her on 3 occasions, and he offered alternative accommodation to her on 3 occasions. Those offers were all rejected. Subsequent to that, on 30 April 2009, Mr. Esop, the attorney for Mr. Grobler, approached Mrs. Phillips and again offered alternative accommodation, which was rejected. Subsequent to that, on the 5th of May 2009, the attorneys for Mr. Grobler addressed a letter to Ms. Phillips and again offered alternative accommodation in the form of a flat, and the details of which the letter says could be resolved through communication with Ms. Phillips. That
Mr.
was
Voss?
followed up with
Mr.
another
Voss?
letter on the
Mr.
18th
Voss?
of May.
Mr. Voss, I'm
Yes,
sorry
ma'am.
to interrupt you whilst you are responding to my brother Mathanga. Can you please refer us to the offers? You started referring to 2 offers that were on the table prior to the magistrate court proceedings. Are you able to refer us just to the pages, not
Yes,
to
yes,
just to give us references to those offers, please? If this is going to delay you, you can do it at a later stage.
I have the reference, the 3 oral offers that were made, we find at page 806, paragraph 20, where Mr. Grobler says, after I purchased the property, I met with Mrs. Phillips on 3 occasions at the property. And paragraph 21, he describes the alternative accommodation. And this is not disputed in response. So those were the 3 occasions where Mr. Grobler met Ms. Phillips in person. The second one to which I've referred is the attendance by Mr. Esop on 30 April. And that reference is in paragraph 10.4, record 62. Where Mr. Grobler says, and I translate this freely from Afrikaans, the offer that was made was that I would purchase a flat in my name in which she could then reside, and the right of occupation would then be registered. That is what Mr. Grobler says. The date of the meeting is found at record 10, paragraph 13. There, Mr. Grobler says, nie teenstaande respondent se onregmatige okkupasie het ek via my prokureurs weer gepoog om respondent alternatiewe akkommodasie aan te bied. My prokureur het op 30 April 2009 mondelingse aanbod aan respondent gemaak, welke aanbod respondent geweier het. And then the last 2, the letters that I referred to, the court will find at page 816. And also at page 817, those are the letters that were sent on the 5th of May 2009 and also on the 18th of May 2009. And then in further response to a question by the court,
or perhaps therefore for completeness on the question by my sister Justice Chike, you might also want to refer Mr. Voss to paragraph 13 of the answering affidavit at page 32, where Ms. Phillips actually admits the offer made by Mr. Grobler's attorney. That is the offer referred to in paragraph 13 of the founding affidavit.
Indeed, my lord. It actually starts on page 30, paragraph 7. Where Ms. Phillips says in paragraph 7, ek erken dat my seuns vir die applikant gesê het dat ek sal trek as hy vir my 'n huis koop. And then lower down she says, verder wou die applikant ook al vir my 'n 2-slaapkamer woonstel koop op voorwaarde dat ek sal trek. Translated, she says, she admits that my client offered to buy a 2-bedroom flat, but what is telling about this is what she says in this paragraph 7 at page 30. She says, ek het die applikant se aanbiedinge geweier. I refused the offers, particularly because the property is valuable and she has the right to live there. So that is where she admits the offer of alternative accommodation being made, and she admits that she rejected it. And then together with the passage in paragraph 13.1, page 32, where she says, ek erken dat ek die applikant se prokureur se aanbod vir alternatiewe akkommodasie geweier het. On a proper reading of these papers, the reason for the refusal is that she believed that because the property is valuable and because she believed that she had the right to live there, she was not going to move. The magistrate also found that no offers of alternative accommodation were acceptable to Ms. Phillips. So in summary, prior to the proceedings being instituted in the magistrate's court, there were 3 occasions where the parties met personally. There was one where Mr. Esop met with Ms. Phillips and offered alternative accommodation, and that was followed up by the 2 letters. And the 2 letters are important because it says specifically the finer details can be sorted out. So that was an open invitation, an open offer to engage with Mr. Grobler about the wishes of Ms. Phillips. Unfortunately, there was no engagement. There was an outright rejection of all these offers. So those were the offers pre-litigation. And then in the SCA issued directives that my client should formulate an offer, which he did. It was submitted to Ms. Phillips. 11 properties in Somerset West were identified, in which she was asked to engage with Mr. Grobler about those properties and to choose one. 3 of those properties were viewed, the rest were not viewed, and all those offers rejected. So that offer in the SCA arose as in response to directions that the SCA made. And the record shows that Mr. Grobler tended to consent to an order in those terms in the SCA. And his position today is in the Constitutional Court that he repeats that tender and that offer of the alternative accommodation that he has made. That is his position about the alternative accommodation. Unfortunately, Ms. Phillips has not reverted with any suggestions about what would satisfy her needs. There have been no counter proposals, merely a rejection.
Mr. Forsyth, I read you were setting out two issues for determination. I engaged you on the first one. So if you might want to go back to where you were. Yeah.
Thank you.
Before Mr. Foss goes there, Justice Madlanga, through you. Mr. Foss, can you help us? There was an offer that was made just after the judgment in the magistrate's court. Let me bring my laptop close to me because I can see you not hearing me properly. There was an offer that was made in the magistrate's court. Remember, just after judgment was made, there was an offer that was made by your client or by yourself during argument, I think.
Yes, I think the court may perhaps be referring to the offer of providing accommodation for Ms. Phillips for a period of 12 months.
Yes, yes, I'm referring to that. What happened to that?
I beg the court's pardon?
What happened to that?
That offer was also rejected. None of the offers that were made were accepted by Ms. Phillips, unfortunately. And as I've yes.
I was following up on the counter offer issue. I was wondering whether there was a counter offer to that. You find that offer in page 527 in court when Mr. Leroux was addressing the magistrate's court.
Yes, unfortunately, and in response to the question by the court, there has been no counter offer and there's been no acceptance of any of the offers of alternative accommodation.
Thanks. Thank you, Justice Madlanga.
If I may then proceed with my submissions and dealing with the second question, and that is the issue whether a property owner is obliged to endure an unlawful occupier for some time or indefinitely. May I refer the court to the well-known case of Blue Moonlight, paragraph 40, decision of this Honourable Court in 2012, and I quote, "It could reasonably be expected that when land is purchased for commercial purposes, the owner, who is aware of the presence of occupiers over a long time, must consider the possibility of having to endure the occupation for some time. Of course, a property owner cannot be expected to provide free housing for the homeless on its property for an indefinite period. But in certain circumstances, an owner may have to be somewhat patient." I submit.
Mr. Voss, could I please come in here, Mr. Voss? In relation to your two questions, and antecedent question must be what would engage the jurisdiction of this court, whether a constitutional issue arises or whether an issue of general public importance emerges as a point of law. Now, as I understand it, Mr. Voss, the SCA did not lay down any principle that an unlawful occupant may well occupy indefinitely. What the SCA did is it considered the appeal and asked itself whether the High Court had correctly exercised its discretion in coming to the conclusion that an ejectment would not be just and equitable. And it did so on the basis of the peculiar and unique facts of this matter. It didn't lay down a binding principle for the future with regard to the circumstances under which an unlawful occupant may well be entitled to continue in occupation. And so my question to you is, what constitutional question needs to be determined if indeed the appeal really revolves on a determination of whether it was just and equitable to order the eviction? The court found it was not. And Section 4, subsection 7 contemplates that in any event, it accepts the position that even an unlawful occupant may well be on the correct side of a determination by the court that the ejectment is not just and equitable. So that's not unusual in that sense. The architecture of the legislature, in fact, contemplates that situation. So is this just not a factual, an appeal on the facts that we're asked to consider then? And how does it engage our jurisdiction?
With respect, the answer to the question, I think, is twofold. Firstly, the eviction from somebody's home or not always raises a constitutional issue. Secondly, I submit that the principles that have been laid down in Blue Moonlight are principles of general application, if I may call it the sometime principle. In other words, that the landowner is obliged to endure an unlawful occupier for some time and not indefinitely. The effect of the SCA judgment is that it is in direct conflict with the guiding principles of this Honourable Court in Blue Moonlight, relating to the issue whether occupation should be endured indefinitely.
But Mr. Voss, the effect of the SCA's ruling is not to direct that the unlawful occupant be accommodated indefinitely. I mean, the fact that she's 85 years old surely was a factor in how the court exercised its discretion ultimately. And so when the court says for some time, it doesn't place a sort of definitive timeline. Some time could differ depending on the particular peculiar circumstances.
Indeed. If I may respond to that and refer the court to obviously the well-known matter of Barron versus Claytile, where this Honourable Court said very much the same, where it said that in paragraph 43 of Claytile, where it said, Blue Moonlight is applicable, although it deals with the provisions of PI insofar as it cannot be expected of the first responder to accommodate the applicants indefinitely when an offer of alternative accommodation has been made. I submit that those words find application in this matter. It cannot be expected with respect of Mr. Grobler to endure Ms. Phillips indefinitely when an offer of alternative accommodation was made, when several offers of alternative accommodation were made pre-litigation. Under those circumstances, it is not just and equitable to refuse an application for relocation, especially if one has regard to the facts in Claytile where the occupiers were moved 30 kilometers away to Wolverrivier, where in this matter, Mr. Grobler is merely asking that the lady relocates within a radius of about 5 kilometers, still in Somerset West. Because in that case, her right to adequate housing, suitable adequate housing, is protected. She will have security of tenure to be registered against the title deed. There will be a court order. Under those circumstances, she will have safety. She will be in the same environment. She will still live in Somerset West. She will be close to her children. She'll be close to schools, close to shops. She'll be close to the hospital. There will be no material change, adverse material change, if she is directed to relocate. And then, if I may, within that context, refer the court to what was said in Claytile, that in inquiries of this nature, where elements of compassion and grace should be infused into the inquiry, there must be some give by both parties with respect. There's been an enormous give by Mr. Grobler. There's been no give by Mrs. Phillips. She is not given with respect an inch. She says she stays put. She doesn't move at all. The effect thereof is that for practical purposes, Mr. Grobler's property rights have been sterilized. He cannot bring his elderly parents to come live close to him, and the property in question is about 500 meters from his own property. So does the law require under these circumstances that Ms. Phillips should also give, should also compromise? I submit yes. And if one has regard to the consequences of a relocation, it is telling that in the magistrate's court, Ms. Phillips did not say that her dignity will be impaired or that it will be difficult to move or that a security of tenure will be affected. What she said in the magistrate's court is that she will move if a house is purchased for her, and the inference is that a house should be bought for her to the value of about 2 million rand. The inference is that the house should be registered in her name. If she could get a house in her name and get property rights, then she would move. So that was the first reason for the objection. She said the property is valuable, and secondly, she said she has the oral right of arbitrature. Those were the two reasons that were advanced. And those matters with respect have been dealt with. They have been adequately safeguarded.
Mr. Voss, on the assumption that what has been put to you by my brother Kolapen on the jurisdiction, whether this matter is a factual matter or engages the jurisdiction of this court, you have put up an argument that the judgment of the SCA cannot stand, and that this court merely, this case is about the exercise of a discretion by the High Court as well as the SCA. In other words, you contend that the two courts did not exercise their discretion properly as envisaged in Blue Moonlighting. Now, what I want to put to you is, Ms. Phillips says, well, it's common cause, and that she's been offered various alternative accommodation, which she has rejected. Now, how far and to what extent must Mr. Grobler go in ensuring that he secures the eviction of Mrs. Phillips from the property? I'm putting this to you to say that if Ms. Phillips says she wants to remain on the property for the rest of her life, we don't know how long she will live. If the authorities tells us that a landowner or a private landowner like Ms. Grobler must endure and accept that the unlawful occupier would be in the property for quite some time. Quite some time has not been defined, and an indefinite period has also not been defined. These are all fact-based inquiries, and they should not be taken in isolation. If one were to look at what happened in Blue Moonlight, there was a period between securing or providing alternative accommodation and the eviction. That's where the indefinite or definite period was contemplated. In this case, Ms. Phillips has dug her heels, has said, I'm not going. You've shown me 3 properties or 11, offered me 11 properties. I'm not going. For as long as I live, I must be in that property indefinitely. In other words, I'll put it as low as this. Wait for me, excuse me if I put it wrongly. Wait for me until I meet my maker before you can get your property. And that may be quite problematic. And I just want you to address that aspect and clear my mind whether one would have to wait. And looking at what a judgment of this court, if it were to adopt that approach, what would happen? Because forward-looking, you could have other respondents who would present their peculiar circumstances and with the habitatio there or no habitatio, and say, wait for me until I meet my maker before I can vacate the property. And whether that can be acceptable in a constitutional democracy, because we have to balance the interests of the landowner and other people. Well, I don't. Let me stop my sermon.
Thank you for that proper question. I would submit in response to that the starting point is the Constitution that provides that Ms. Phillips should have adequate housing. She should not have housing of her choice. Within the context of ESTA, it has been stated by the Constitutional Court and also the SEA that in those circumstances, an occupier does not have the right to choose a particular property. But coming back to the facts of this matter, Ms. Phillips has been exercising the sometime principle now for nearly 14 years. This matter started in 2008, 2009. She has been in that property for more than some time, and I use the word sometimes within the context of the Blue Moonlight judgment. Indefinitely can only mean, I submit, until an occupier's death. The Constitutional Court has said in Blue Moonlight that an unlawful occupier may not occupy premises indefinitely, put differently, till the death of the occupier. But within the facts of this matter, and especially where alternative accommodation has been offered, which is upmarket accommodation in Somerset West, with safety, with security, that would be just and equitable to both parties. And it would not be in conflict of the sometime principle, the Blue Moonlight principle, and also the same principle that was enunciated in Claytile. In Claytile, the court will recall that the occupiers had been endured for about 5 years. And the Constitutional Court respectfully said that's long enough. We are now in this matter beyond 13 years. In Blue Moonlight, the one occupier was in the property for 35 years. He passed away at the date of the hearing. Another one was in the property for 21 years. The court held that that was long enough. In applying those principles, the Blue Moonlight principle, I submit that we have passed the threshold of some time. We are now already in the realms of an indefinite period. And that
Excuse me,
is not...
Mr. Foss, excuse me. I forgot to put to you Ms. Foss' right of habitatio, registered or not registered. And if she has conducted herself on the basis that prior to Mr. Grobler purchasing this property, she had this right of habitatio, which for obvious reasons could not be registered then. And she says, when I moved into this property, I was assured that I would be in this property for the rest of my life. And now I am surprised when I'm asked to vacate the property. I just want you to deal with that aspect as well. And
Thank you. The oral right of habitatio is invalid. If the effect of the SCA judgment is that it has converted an invalid right into a valid right, that is the objective effect. The objective effect is that she now has an unregistered invalid habitatio that the SCA acknowledges as valid, because that's the only reason, that's the only justification for permitting her to stay in the property. And that would be contrary to well-established legal principles that I respectfully submit that a court should not convert an invalid right to a valid right. And the facts of this matter are to a large extent similar to Blue Moonlight, because in Blue Moonlight, the occupiers had the right to reside there. They had the right to reside there for between 20 and 35 years. They had the permission of the previous owners. They were paying rent. But at some stage, around about 2004, their occupation became unlawful. And in this matter of Mr. Grobler and Ms. Phillips, the same situation applies. Previously, the occupation of Ms. Phillips was lawful, and in 2008, it became unlawful. I submit that it's common cause that in 2008, the occupation became unlawful. So we are now into the 13-year period, which is past some time. And in applying the Blue Moonlight principle, that is in conflict. The 13-year period is in conflict with the sometime principle. I hope that I answered the question.
Mr. Voss, doesn't this matter also forces us to have a look and focus on section 26.2 seems to be saying that the state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of this right. Why am I asking this question? There seems to be some suggestion in the papers that Mr. Grobler was obliged to provide alternative accommodation. And I wish to clear that in my mind. Does the Constitution impose the obligation on him, or does it impose the obligation on the state? Under what circumstances is that obligation on the private landowner when an eviction due to an unlawful occupation is imminent?
My submission in response to the question is that there's no duty on the private landowner to provide alternative accommodation within the context of a PI eviction application. We do find some guidance in clay tile, because in clay tile, if I may just find that was dealing obviously with Esther. At paragraph 37 of clay tile, this honorable court said, the provisions of Esther do not spell out who's responsible for making available suitable alternative accommodation. The logical role player would be the state. And then lower down, eviction under those conditions should therefore be allowed only in exceptional circumstances. Within this narrow scope, it might therefore be appropriate to expect the private landowner to assist with the finding of, or failing that, in truly exceptional circumstances, to provide suitable alternative accommodation. So it would appear that the approach of this honorable court within Esther is that only in truly exceptional circumstances must the private landowner provide suitable alternative accommodation. Within the context of PI, on my reading of section 4.7, I don't see any statutory obligation upon a private landowner to make alternative accommodation or alternative land available. But having said that, in this matter, Mr. Grobler has made numerous offers of alternative accommodation, and the court is no doubt aware of the tender in the heads of argument and the tender in the affidavit that he submitted in the Constitutional Court that he consents to an order that he will provide alternative accommodation at his cost. And that also follows substantially the same tender that was made in the Supreme Court of Appeal before the judgment in the Supreme Court of Appeal. So he takes that obligation upon himself. As the court pleases.
Mr. Foss, I wonder whether I could ask you this. What supervisory jurisdiction does the High Court and in turn the Supreme Court of Appeal have over the exercise of the discretion as to what is just and equitable that the Magistrates' Court made? In other words, what I'm interested in understanding is, properly understood, when a court, in this case, at the outset, the Magistrates' Court, makes a just and equitable determination, what is the basis for an appellate court then interfering with the exercise of that discretion? That's the first part of the question. And the second is that issue as to the nature for intervention by an appellate court a matter that concerns our jurisdiction? In other words, is clarifying that question a matter that might concern our jurisdiction?
Thank you. If I may respond to that.
Yes, please. Thank you.
Thank you. With regard to the first question, I would submit that the discretion of the Magistrates' Court is subject to scrutiny to ensure that the magistrate exercised its discretion correctly on principles of law, and that all relevant facts were taken into consideration when the order was granted in respect of an eviction order, because that is my understanding of the law, that all relevant facts should be taken into consideration. So in other words, are you saying the standard for intervention is not correctness? In other words, not whether the appeal court might have reached a different conclusion on the facts, but whether there has been some misdirection either as to law or as to some failure properly to take account of relevant facts? Yes, indeed, that is my submission. In particular, with regard to the judgment in the order of the SCA, my submission is that the Constitutional Court may intervene because the Supreme Court of Appeal applied the sometime principle incorrectly. The constitutional imperative is that an unlawful occupier may remain in premises for some time, but not indefinitely.
Yes, I think you've clarified that point. My question, though, if I may just finally ask you, did the High Court, when it entertained the appeal from the Magistrates' Court, apply the correct principle for appellate intervention?
Thank you. My response to that is that the incorrect test was applied by the Supreme Court of Appeal to intervene. Sorry, the High Court.
The High Court.
Right.
Yeah. Yes. And as to our own jurisdiction over this question, perhaps just briefly, if you could give us an answer on that. Is our jurisdiction engaged on this question of when appellate intervention is permissible?
My submission would be that the sometime principle is the overriding principle. And if a court applies that jurisdiction, that constitutional principle incorrectly, then the Constitutional Court would be at liberty to intervene and to correct that. To put it differently, if all magistrates had to start taking decisions that all unlawful occupiers may remain in premises indefinitely till their death. Such a ruling would obviously be contrary to the constitutional imperative, where the Constitutional Court ultimately would intervene and correct that incorrect judgment, because the judgment would have been brought out applying an incorrect legal principle.
Yes, thank you.
Mr. Foss, to delve a little deeper into the question of the discretion, would it be correct to say that the High Court could only have interfered on appeal if it found that the magistrate's court had exercised the discretion capriciously?
Is the question, could the High Court only interfere if it found that the magistrate?
Let me put it slightly different.
Yeah.
I think, and I do believe Justice Unterhalter was trying to interrogate this question with you as well. Having regard to the nature of the discretion that is exercised by the magistrate's court, the High Court could not have interfered in the exercise of that discretion on the basis that they would have reached a different decision. They could only have exercised, they could only have interfered on appeal. The basis for interference on appeal would be if they found that the magistrate's court had incorrectly or capriciously exercised its jurisdiction. Just looking at the principle of law.
Indeed, I agree with that.
Did the High Court find that the magistrate's court had improperly exercised its discretion?
I believe that such a finding was not made. I'll just check that, but I believe such a finding was not made.
What would the consequence be then if the High Court did not make such a finding? Would it have been entitled to interfere with the exercise of the magistrate's court of its discretion?
My response is, under those circumstances, the High Court should not have interfered.
Now, let's look at the manner in which the SCA dealt with the question of discretion. Before I refer you to the SCA judgment, would you help me with this, Mr. Foss?
Yes, certainly.
Seems to me that let me put it this way first. This was a judgment of the magistrate's court that was on appeal. It was the exercise of a discretion by the magistrate's court. When the matter was on appeal before the SCA, which exercise of discretion should the SCA have been looking at? Should the SCA have been looking at the manner in which the magistrate's court exercises discretion, or should it have been looking at the manner in which the High Court exercises its discretion?
I submit that the SCA should have considered the manner in which the magistrate's court exercised the discretion.
Now, I'd like to refer you to paragraph 48 of the judgment of the SCA, page 793, which you would find at volume 8.
Yes, thank you. Paragraph?
Paragraph 48, Mr. Foss, page 793.
Yes.
In the first two sentences, the SCA is dealing with the nature of the discretion. But it says it need not decide whether it's a true discretion or not. And then look at the third sentence. It says the High Court was entitled to exercise a discretion even though the occupation was unlawful. Now, perhaps I have missed it, but it doesn't seem to me that the SCA considered the manner in which the magistrate's court exercised its discretion. Are you able to assist? Is there anywhere in the judgment where the SCA considers the manner in which the High Court exercised its discretion? I'm sorry. Is there anywhere in the judgment where the SCA considered the manner in which the magistrate's court exercised its discretion?
I believe not. On my recollection and reading of the SCA judgment, that doesn't come to mind now.
So where does that leave us, Mr. Voss? Because we are dealing here, as I understand it, and I may be wrong, and as you've also submitted, with the exercise of a discretion by the magistrate's court. Ultimately, is it not? Whether that discretion was exercised properly or not.
Indeed, I agree with that.
Could I also, while we are at the judgment, take you to paragraph 56 of that judgment, Mr. Voss?
Yes, certainly, I have that in front of me.
Paragraph 56 deals with the offer that was made, and it deals particularly with the offer that was made at the SCA level. I'm not sure if the judgment deals with the previous offers, the offers where the applicant met personally with Ms. Phillips. Does the judgment deal with that?
No, it doesn't deal with that. It deals with the I think with the offer at the SCA level.
Yes, with the offer that it asked the applicant to reduce to writing. Is that right?
Indeed, directions were issued. Yes,
that's the only offer dealt with. It then says, and this concerns me a little, the last sentence in that paragraph. Such an order, that's the order of eviction, subject to the first respondent being accommodated as the applicant had proposed. Such an order would clearly be one made contrary to the first respondent's wishes. Now, in considering whether or not eviction is just and equitable, is that a relevant factor to have regard to? Is that a relevant consideration? Should a court consider whether the person sought to be evicted, whether the offer complies with their wishes?
Before you respond, Mr. Voss, your 45 minutes ended at 10:54. How much more time do you think you want?
Thank you. I have finished with my submissions. I have no further submissions to make. They are all in my heads of argument.
Or you'll just respond to questions. All right, please respond to my sister Justice Theron's question there.
Thank you. I think the question was, should a court consider the wishes of an unlawful occupier? My response to that question is no, because one should have regard to the conduct of Ms. Phillips within the greater context of this matter. Her true wishes were that under no circumstances is she prepared to move. Number one. Secondly, her attitude was, buy a house for me so that I can get ownership of a house and then I'll move. And that, I respectfully submit, is what her true wish was. Nowhere in the replying papers in the magistrate's court did Ms. Phillips say that her dignity would be impaired if she had to go, or her wishes are that she wants to stay there. All these issues.
Mr. Voss, I'm sorry to cut you short, but
yes.
I don't want to look at the facts for a minute. I want to look as to consider the legal principles involved. What is the result of where a court, in exercising its discretion, has regard to irrelevant factors or considerations? What's the consequence of that?
Legally, the wishes of an unlawful occupier are irrelevant, and if a court takes irrelevant considerations into regard, it will be open, at least on that ground, for the Constitutional Court to interfere and correct the wrong that was brought about in the SCA judgment. I've quoted the case in Hunky Dory Investments, High Court in Cape Town. The court said that an unlawful occupier does not have the right to choose where he wants to live. Very much the same as the authorities that I quoted within the context of Esther, the Snyder's case and the Oranje case. The effect of what the SCA said and what the Constitutional Court said, that the right to housing does not come with the choice as to where a person wishes to reside. So within that context, it's a legal concept that should not have been taken into consideration by the SCA.
Thank you, Mr. Frost. Thank you, Justice Mhlanga.
Thank you.
Mr. Frost.
Yes.
But para 57, you may have dealt with this issue. Para 57 of the SCA, that's where it says the offer was made at a late stage. It was belatedly made. You say that, in fact, the offer was made, if I'm correct, on 3 different stages before the institution of the proceedings in the Magistrates Court. Also, after the judgment on the merits during the Magistrates Court stage, and again before the SCA. Is that correct?
That is correct. Just one correction that I wish to make. There were 3, before the litigation started, there were the 3 oral offers that Mr. Grobler made to Ms. Phillips at the house. He went to the house. There were the 3 in 2008. Then we come to 2009. He sent his attorney, Mr. Esop, on the 30th of April, 2009. Mr. Esop went to Ms. Phillips and he offered alternative accommodation. That was the 4th occasion. The 5th occasion was the first letter of 5 May 2009 that the attorneys wrote the letter. And then the 6th occasion was when the 2nd letter went off on the 18th of May 2009. So those were the occasions on which the alternative accommodation was offered pre-litigation. And when all those 6 offers, attempts, when they failed, then ultimately Mr. Grobler commenced with the proceedings.
But if even during the proceedings in the Magistrates Court, some offer was made, yes, albeit it may not have been as detailed as the first ones, because that Indeed. One, the offer was 4,000, I think, per month or something to that effect. But Indeed. An offer was made. Indeed. And then a fuller offer was made during the SCA proceedings. That Indeed. Is when there was an offer to purchase a property.
Indeed. The offer in the SCA was, in practical terms, a repeat of the offer that was made in the letters to the attorney and the oral offers that were made in 2008. It was perhaps just a bit more refined. But given the directions of the SCA, 11 properties were identified that were available to purchase, and they were offered to Ms. Phillips, and she viewed 3 of them. The difficulty that we have is that there was no engaging with us. There was no response. Nobody said to us, we want a house that's painted pink and not white, or we want a carport. We don't have a garage, buy something with a garage, because the current house doesn't have a garage. Nothing of that came back to us, so we couldn't engage. And the difficulty that my client has is he can't go out now and buy a house in Somerset West and says, I've bought this house for 2 million rand or for 1.5 million rand, and then Ms. Phillips says she's not going to move. That's the difficulty that we have.
And that offer is still on the table. That is, yes, the property indeed. Will be registered in the name of the applicant, and the respondent will be, the right of habitatio will be registered. Is that correct?
Indeed, that tender is in my heads of argument. It's up front in the heads of argument. And there's also an affidavit that has been filed in the Constitutional Court where my client sets out that he consents to such an order. Perhaps I can just find it in my head to assist the court. If I could ask the court to turn to page 3 of my heads of argument, paragraph 3. The applicant consents to an order in the following terms. The important part is paragraph 4. The applicant is directed to purchase a 2-bedroom dwelling in a good condition. The new dwelling shall comply with the following requirements. It shall have at least 2 bedrooms, which is the same that she has now. It shall have a lounge, kitchen, and a bathroom. It's the same that she has now. And the dwelling must be situated within a radius of 5 kilometers from 59 Dummer Street, Somerset West. And then paragraph 6, in response to the question of the court, is declared that once the new dwelling is registered in the name of the applicant, Mrs. Phillips and Mr. Adam Phillips shall have the right to reside in the new dwelling for the rest of Ms. Phillips' life, and the applicant is directed to register the aforementioned right against the title deed of the new dwelling. That is the safety and the security that we offer to Ms. Phillips. And then paragraph 7, we'll arrange for and pay for a relocation cost. She won't have any cost of relocation. The rest is detail about municipal services, which isn't important. But that's the heart of the offer that has consistently been made. Perhaps it's a bit more refined now. And if I may, in response to the question of the court, we are dealing on the version of Ms. Phillips with a small and a modest house. These are the words that she uses. And if I may ask the court perhaps to turn to volume 1. Page 33. Page 33, paragraph 17. It is in volume 1. In paragraph 17, she says, die huis bestaan uit 2 slaapkamers, 'n kombuis, 'n sitkamer en dan 'n toilet en badkamer saam met 1 vertrek. That is exactly what we are offering. In vergelyking met die uiters luukse huise in die omgewing waar ek woon, is dit 'n klein en nederige woning. Freely translated, it is a small and humble residence. That is what we offer. We will give exactly the same that she has.
Thank you, Mr. Foss. One last question. My reading of the SCA judgment when it dealt with the question relating to the tender of free alternative accommodation, it does not appear to have made a finding on the suitability or inadequacy of this alternative accommodation. Is that a correct understanding of the judgment?
That is my understanding. It effectively didn't deal with it, which I respectfully submit is incorrect, because those documents, the tender, came about as a direct result of a direction that the SCA issued. The SCA directed the parties to do that. So the SCA actively infused potentially elements of grace and compassion in these 2 competing interests between the parties. So having done that, and the parties having engaged with one another, the SCA, with respect, ignored that compelling evidence that was presented to it at its own request. And nowhere is there there's no glaring evidence that the alternative accommodation that has been offered is not suitable.
Thank you, Mr. Foss. Thank you, Mr. Foss. Sorry. Thank you, Justice Matlanga.
May I just follow up, please, Justice Matlanga? Mr. Foss, just you've been asked about these offers. The offers that were made pre-litigation in the Magistrates Court, of course, they were only open for 10 days, so they lapsed by the time the trial started, correct?
The offers were not open only for a limited period. With respect, those offers were made, and Ms. Phillips was asked to engage with Mr. Grobler. But the magistrate found that no matter what was offered, they would all be rejected. That is what the magistrate found.
Yes, but let's just look at the record. Pages 25 and 26 are the attorney's letters which set out the oral offers. And the last paragraph says, "Bogenoemde aanbod is koop vir 10 dae na ontvangs van hierdie brief, waarna ons instruksie is om voort te gaan met uitsluitingsprosedure. They open for 10 days, failing which there will be eviction proceedings." My point is this: there was an offer made during the hearing before the magistrates court. You've already referred us to it in page 5 to 7 of volume 6, where the attorney for Mr. Grobler, Mr. Leroux, addressed the court and made the offer for a 12-month residency in a retirement village and costs limited 4,000 per month. That was made during the hearing.
Indeed.
And Mr. Julius for Mr. Phillips said, well, he has to take instructions, but in any event, his instructions are to appeal. And that officer was then impliedly rejected. Am I correct with that?
Indeed.
Now, my question is this: you've been asked about the discretion by the magistrate. Is this aspect also an aspect that was taken into account by the magistrate in his judgment, that there was an offer, but it was rejected?
Indeed, I can find that reference in my notes.
Yes, no, it's not necessary. I just want to confirm that. That's how.
Yes, the magistrate specifically said that all offers were rejected.
Yes, I did say that in the judgment. I've seen that. Mr. Foss, are you looking for the passage in the judgment of the magistrate?
Indeed, if my memory serves me, on Australia, my documents, so I think it was in paragraph. I'll find it and then I'll revert.
Look, it's not important. You can even do it in reply. My other question is completely different. My last question, and it's this: you've referred, Justice Mhlantla, to the consent order, the order that you consent to in your heads. You repeated a paragraph. It's in paragraph 3 and repeated right at the end. And I want to ask you this: if you could just look at page 3, paragraph 3 of your heads.
Yeah, I lost the sound page.
Sorry, page 3, paragraph 3 of your heads, and specifically 8 of that offer. Mrs. Phillips and Mr. Adam Phillips will be liable for the cost of municipal services. It's just a small matter. I want to check with you, what is the position at the moment where they are residing in this property belonging to Mr. Grobler? Do they pay the municipal rates, or what is the arrangement? Do you have instructions about that?
Yes, I know what the position is there. Mr. Grobler pays the rates and the taxes.
Yes. And the municipal charges such as for refuse removal, etc. And electricity and water.
My attorney is next to me, Mr. Leroux, advises me that the municipal charges are paid for by Ms. Phillips currently.
Okay. Thank you very much. Thank you, Justice Madlanga. Those are my questions.
Justice Madlanga, if I may, one more question with your leave, please. If I could once again refer you to the judgment of the Supreme Court of Appeal, Mr. Foss.
Yes.
Paragraph 51, page 795. And it was also linked to questions raised and discussed with you by Justice Mhlantla.
Yes, certainly. Paragraph?
In paragraph 51, the Supreme Court of Appeal, in the last sentence, makes the conclusion that the High Court was correct to find that an order of eviction ought not to have been granted by the Magistrates Court. Now, in the preceding paragraphs, it had regard to a number of factors that it needed to consider. It makes that finding and then deals with the question of alternative accommodation. Tends to reinforce the view that it reached that conclusion of deciding whether the eviction order was just and equitable without at all having regard to the question of alternative accommodation.
Indeed. There's little doubt about that with respect.
So as Justice Mhlantla asked you, it didn't consider whether or not the alternative accommodation was suitable. In fact, it would appear it didn't consider anything relating to the alternative accommodation.
Indeed.
And it reaches the conclusion in paragraph 51 and then goes on from paragraphs 52 and following to say why it would not consider the offer regarding alternative accommodation.
Indeed, that is correct, yes.
Thank you, Mr. Foss. Thank you, Justice
you.
Madlanga.
Thank you.
Let us adjourn for 15 minutes and resume at 11:31. Court adjourn.
Court will adjourn until 11:31. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences. Should you exit, you may use the same link to rejoin the hearing.
January, is everybody online?
Yes, Justice. All counsel are online.
Yes, Mr. Fagan. Thank you, Mr. January.
As the court pleases. The rights and needs that are specifically to be considered by a court under section 4.7 of PI are those of the elderly, of children, of disabled persons, and of households headed by women. Ms. Phillips is 85 years old. Her son, Adam, is severely disabled. The fact that his disability takes the form of brain damage means that he is in law a child. And finally, Ms. Phillips heads the household. So those boxes, as it were, are ticked. But there are three further factors that...
Mr. Fagan, where the Ms. Phillips's grounds of appeal, in essence, to the effect that the magistrate had exercised the discretion in a manner that was not judicial.
In fact, as I shall show, as I endeavor to show the court, she exercised no discretion at all under section 4.7. She understood it to be purely a legal question of whether or not there was a habitatio which protected her. Having found that there was not, the court then said, and that's the ratio of that judgment, then simply said, well, she has no legal right to be there. She's an illegal occupier, and therefore the court evicts. Perhaps I should take the court there because it is a really important issue in this matter. If I might ask the court to go to volume 6 of the record at page 514. And at the foot of page 514, the court, with respect, correctly says how it should approach the matter. From line 16, should this court find that there'll be an unlawful occupier, this application must fail. That's overstating it, but the court does then qualify that. Should the court find the respondents are in fact are unlawful occupiers, the act is very clear and the wording is quite specific. It reads that the application in terms of PI may succeed, not must, may succeed. It opens the door to some degree of discretion on the side of the court. Thereafter comes the last step in this court's determination, and that would be whether it would in fact be just and equitable to grant an eviction given the facts of the matter. And of course, in formulating in this way, the court is not approaching it in the same way as the SCA said one should in changing tides, but one leaves that aside. And then the court said, top of page 515, secondly, to determine a just and equitable period, that's the section 4.8 inquiry, within which an eviction should take place, given the facts and unique circumstance of the matter. Then the court says this: at the commencement of this application, this court was informed by both counsel that all other issues had been settled, and the only issue for the court to determine was, in fact, whether the first applicant held some title to her occupancy. In other words, whether her occupancy was in fact lawful or not. Then at page 520, at the top of that page, the court says there may be a claim. This is a claim to occupational right, but it does not establish a right. And therein lies the problem for the respondent in the matter. At line 13, the question is not whether she resides there. The question is whether she has a right in law to be there, and whether that right was in some way recorded. And the only way it could have been recorded would have been at the deeds office as part of the title. That is a problem. It was not recorded. And then this leads then to the conclusion on page 522. I'm satisfied that the applicant has satisfied his burden in establishing his right of ownership over the property, that the respondents at this stage, in fact, are living on the property without the express or tacit consent of the current owner, that in law they have no right to occupancy. And as I've said before, it is inexplicable as to why a claim was never pursued, and at this stage of where the process sits, this was a suggestion of some kind of counter application for registration of habitatio. The first and second respondents certainly don't have a right in law to occupy the property. And then for those reasons, the court must find in favor of the applicant. This application in terms of PI must succeed, and the eviction of the first and second respondents is hereby granted. So simply the magistrate quite failed to exercise the judicial discretion vested in a court by section 4(7) of PI, and that is a fundamental misdirection. What it means is that the first time a discretion was exercised was by the High Court on appeal from this decision.
Mr. Fagan, Justice Madlanga, if I may, just on that point, just to correct something I said to Mr. Force earlier. Of course, that offer at page 522 was made at the application for leave stage. So that couldn't have been considered by the magistrate as far as the discretion is concerned. Just to correct that.
With respect, Justice Majid is quite correct. It was a point that I wish to also raise at page 527. Yes. What happens is after the eviction order is granted, now the magistrate entered into the investigation under section 4(8) of PI as to what would be a suitable period, what would be a suitable time for the eviction to be ordered. And it's only in that context that this very, very limited offer of accommodation is made at 527.
Yes, you're right. I just wanted to correct that, but I have another question, an antecedent question. There was some discussion with Mr. Voss about, I think my brother Kolopin J raised it first, the question of jurisdiction. Do you accept that this court has jurisdiction to hear this application?
We said in our affidavit opposing this application that this is not a matter that requires this court's consideration because it's simply an application of known legal principle. It raises no new issues. The applicant has used somewhat, we would submit, extreme language in suggesting that it does engage this court, calling it an expropriation, for example, which it clearly is not. It's simply a limitation on the bundle of property rights that an owner has. So some kind of deprivation for a period, but there's no expropriation. There's nothing contrary to blue moonlight in the judgment of the SCA with respect. There's no principle that is raised by that court. It's simply an application of what are by now well-established, jurisdiction in regard to section 4(7) of PI. So our submission would be that it doesn't.
Sorry, can I ask you then, what about Mashal versus Mailula?
Yes.
In that case, in paragraph 25, Justice Cuellar wrote for the court, his unanimous judgment said the following. He deals with the history of forced removals and so on, and he says, we now have a constitution which specifically protects against arbitrary evictions. And this is the important part. In my view, an eviction from one's home will always raise a constitutional matter. Further, in the Jafta case, Mokoro J said that, quote, at the very least, any measure which permits a person to be deprived of existing access to adequate housing limits the rights protected in section 26(1), close quote. Now, to my knowledge, that is still the jurisprudence of this court. I'm not aware of a case that has said something different. So what about that case then?
With respect, Justice Majid, I don't suggest it doesn't raise a constitutional issue. What I'm suggesting is that this application for leave to appeal should not be granted by this court because nothing new is raised in this case on the facts of it, on the application of the law. In other words, what is necessary to be shown, not only that it's a constitutional matter, but also that it should take up the time of this court, as it were. Well, that's an application for leave to appeal. But that's the second of our submission.
Sorry to interrupt, but that's the second leg. The question then in the second leg is, once we establish that it's a constitutional involved which engages this court's jurisdiction in terms of 1673, The next question is it in the interest of justice to hear it? And that's the question of, is there a novel point of law? But my question is restricted to the first part. You accept that it raises a constitutional issue that engages the court's jurisdiction?
We do not dispute that issue. Yes,
Okay.
we've only addressed the second issue. And I believe in our answering affidavit we confine it
Yes.
to that point.
Yes. Thank you, Mr.
Thank
Fagan.
you.
Thank you, Justice Matlanga.
Yeah, I was suggesting to the court with respect that there are three further factors that make this case.
Mr. Fagan, I'm sorry if I had to interrupt you, but just to backtrack slightly before the point is lost. At page 515 of the record, you took us there.
Yes.
There seems to have been some agreement between counsel before the magistrate that the only issue for the magistrate to consider was the legality question of occupation, which would suggest that there may have been some understanding that the justice and equity part of the deliberation was agreed. It may still leave open the proposition that the magistrate still had to exercise that discretion irrespective of the agreement of counsel. But I'm just wondering if you can assist us to understand what happened in the magistrate's court, because the magistrate raises the justice and equity issue.
Yes.
And then doesn't deal with it, possibly because of this agreement that is reflected at 515.
I unfortunately was not involved at that stage, Justice Unterhalter. Mr. Morrissey and I only became involved for the first time in respect of the High Court proceedings. So I'm afraid my knowledge of what happened there is very limited. But in any event, as one knows from the jurisprudence in regard to Section 4.7, nothing overrides, as it were, the requirement that the court must always still exercise its just and equitable discretion under that section. In other words, irrespective of what might have been said by parties, the court must still come to that, come to a decision on that.
That may be right, but then the High Court would only have been able to intervene on a very limited basis, which is to say, in the face of an apparent concession that your client was not contending for any injustice or inequity.
Yes.
What was the residual discretion of the court to do in these circumstances? It would be a very different inquiry from what actually happened in the High Court.
Yes, I'm concerned that one doubts very much that there could have been an agreement from Ms. Phillips' side saying, I recognize that if I don't have a registered habitato, I don't have a legal right to be here, my eviction would be just and equitable. That, with respect, seems to me something she probably wouldn't have agreed to. I'm just being shown something. If you give me one moment. Oh, yes. I see at the SCA judgment may be addressing this in volume 8 at page 784. Because certainly what did come up for debate in previous courts was whether Ms. Phillips enjoys ESTA protection or not. And a point that was raised is, no, you can't raise that against it. It was agreed that it's only a PI application. And on page 784, in paragraphs 20 and 21, the court will see that the SCA addresses this issue there. And that certainly, I do know there was some kind of statement made early in the proceedings that this is a PI application. And when we therefore on appeal before the High Court sought to introduce ESTA, there was an objection to that. But I don't believe it would go further than that with respect.
Thank you, Mr. Fagan. Thank you, Justice McLean.
So the factors that make this case particularly unusual or unique, and these are factors that weighed with the High Court and the SCA in exercising the judicial discretion not to evict under Section 4.7. The first is this: Ms. Phillips did not invade someone's land. Ms. Phillips did not erect a house on someone else's property. Ms. Phillips simply continued to live in the farm worker's house that she has been living in from the age of 11 in 1947. Lived there with her parents, with her husband, with her children. She would have enjoyed almost complete protection under Esther from being evicted from her farmhouse, but there were events that took place around her. This is tragic for this reason. She lost on the SCA's judgment her Esther protection because this farm was cut up by developers, originally by the owner, then by developers, further cut up and taken into the Somerset West urban edge. So the farm became urbanized. So now her house is not a cottage on a large farm, it's now a house on a single property, small property. So she lost that complete protection she would have enjoyed under Esther and is now driven to seeking to avail herself of Section 4(7). But we submit that that is a very significant and important factor. She did nothing active. She just remained where she was and lost the protection in this way. The second unique factor is that on at least 2 occasions, previous owners of the property on which her house is situated recognized a lifelong habitatio. It isn't necessary to decide whether on a 3rd occasion, Mr. Rex Ince also did so. There's a dispute about that, but there's no dispute about the fact that Mr. Heinrich Rack and after him, Quickcon Development Pty Limited both recognized that right. It's contained in a written agreement. I don't need to take the court there, but it's in volume 1 at page 38, clause 4.2. But for the liquidation of Quickcon, she would have had no difficulties. Is stipulatio alteri, she could have enforced a right against Quickcon. But also, but for her socio-economic situation and her illiteracy, there would have been no difficulties either. She would simply have registered her habitatio against the title deeds. The constraint that would have applied to Mr. Rex Ince's lifelong accommodation offer, if there was such an offer made, that constraint of the Group Areas Act ended in June 1991. Prior to that, of course, she could not have had it registered. After that, she didn't know that she needed to have it registered. She could have converted her personal right into a real right incredibly easily, if only she were not in the socioeconomic situation in which she is, and if she were not an illiterate person.
Sir Fagan.
Yes. Yes,
can I ask you a question just on the issue of equity? And justice in eviction proceedings. We've read the papers. We are aware of all these factors, like the age of your client, the fact that she was under the impression that she had a lifetime right, and it turned out because it was not in writing, she didn't have. And the position with her son and all of that, and the fact that she could have been protected by Esther, but because of circumstances beyond her control, she was not protected. Now, if we take those in your favor, should we only focus on those and not look at Mr. Grobler's position?
No, certainly, but the court must of
Does
course
this
balance.
not entail, yes, does this not entail a balancing exercise?
Yes.
And speaking for myself, when I realized that even though there was no obligation under PI for Mr. Grobler to make an offer of alternative accommodation, I just thought to myself that perhaps these are the considerations why he thought that he could, under the circumstances of this case, or whether that he should offer alternative accommodation.
Yes.
Should we ignore the fact that alternative accommodation here is being offered? And taken with that, the property rights of Mr. Grobler as well.
Yes. With respect, that must clearly weigh in the balance. That must clearly be, these are factors that the court must take into account. But I would ask the court to bear in mind that at the time of the magistrate's court proceedings and at the time of the eviction order by the magistrate's court, there was no such offer. There had been offers made through attorneys. Mr. Justice Majid referred to those. They were for a short period, they lapsed. When the magistrate's court heard this.
I'm going to seem as if I'm interrupting you. Forgive me if it appears that way, but I just wish to debate this issue with you.
Mm-hmm.
Yes, those offers were made just for a period of 10 days.
Yes.
But the flip side of it is that there was no request for an extension either.
Yes. Might I, sorry, I do apologize. I wasn't meaning to interrupt. I thought you'd finished. Yes, Justice.
Yes, I'm done on that point.
Thank you. There's something that one is at risk of overlooking in this matter. It has to do again with the extremely vulnerable position in which Ms. Phillips found herself, her ignorance of how the world works. She believed that she owned her house. She said so over and over in her evidence in the magistrate's court. If I might take the court there, it's a matter of real significance. She thought Mr. Grobler was offering to buy her property from her. That was her understanding of it. It was misguided, but she actually explains to the court, it's my house, I own it. And she believed, actually, she explains how she came to own it. She said, I earned it. I worked very hard for many years, and this house was given to me. So she understood the offer from Mr. Grobler, completely misconceiving it, but she understood it to be that he wished to buy her property from her. And she was an unwilling seller. And of course, you're entitled to be an unwilling seller. It's nothing unreasonable.
Mr. Fagan, excuse me. I mean, she had legal representatives advising her. Whatever her belief may have been about her being the owner could and should have been clarified by legal representatives to say all that you had was a right to live in that property, not necessarily that she was the owner. Let's put those facts in the proper perspective.
But that would be at the magistrate's court proceedings. But we're talking about prior to that, when Mr. Grobler makes the offer. Now she rejects it. And she rejects it. We see this in volume 2 at page 141.
Mr. Fagan.
Yes.
Well, we are aware of what she said when she rejected the offer.
Yes.
What my sister Chick is putting to you is an exercise of the competing or balancing the competing rights of Mr. Grobler and Mrs. Phillips.
Yes.
You have sketched to us, which we are aware from the records, her socio-economic conditions.
Yes.
But if I were to put this to you, what Mr. Grobler is proposing is not going to displace her or affect any of her socio-economic rights. You may want to say something about that.
Yes.
And it talks to whether it was just and equitable for the magistrates to order the eviction.
Yes.
Just before I get off, my follow-up question would be, having a look at the consent order, which has been repeated in these proceedings this morning, what is wrong with it? All what Mrs. Phillips would have, together with her disabled son, would be a roof on their heads with similar accommodation as the previous house that they are currently living in. If she were to complain about being far away from her friends or whatever, the distance, we are told, is 3 to 4 kilometers. And when we have to compare that with what this court said in Clayton, where the distance was about 30 kilometers,
Yes.
would you contend that there would be any disruption in their life, in their family life at all? They will all be accommodated, herself and the disabled son. And here's an offer. And when you look at the practicalities and taking a step backwards, you're looking at the rights of Mr. Grobler, you're looking at her rights, Mrs. Phillips, and you would ask the question, if she moves out of the property, would she be in a worse position than ever before? If the answer is no, then the eviction would be just and equitable. You would look at the surrounding. Where are you putting me or placing this person? In a house that is of similar status to her house. That's why I leave it at that.
But again, with respect, Justice Matoko, before the magistrate, there was no such offer. Before the High Court, there was no such offer. This court is now, there's an application for leave to appeal to it, with a tender that was made for the first time in any legal proceedings during argument in the Supreme Court of Appeal. The High Court's decision, where it exercised a judicial discretion under Section 4(7) in our submission for the first time, could have no regard to the question of alternative accommodation because none was on offer. And insofar as this court will be sitting as a court of appeal, it must consider whether the High Court weighed the considerations correctly, and it had no consideration before it of alternative accommodation. And that, with respect, is an important factor to consider insofar as it's a court of appeal. If this court says, but we are now seized of this matter de novo because there's something now that's new, well, that would be a different issue. But my respectful submission is there's an application for leave to appeal here and a belated tangential tender, as the SCA with respect correctly depicted it. And this court's now being asked to overrule a decision ultimately of the High Court, a discretion exercised by that court, which could not weigh in the balance any offer of alternative accommodation because it didn't exist at that time. The order that was sought, and it's on page 4 of the record, was simply evict Ms. Phillips. That was the magistrate's order that was sought. There's no tender there.
Mr. Fagan?
So, yes.
Mr. Fagan, did it matter that, and now I'd like us to think of usually what happens in litigation in courts.
Yes.
It mattered that after the order was made, there was some form of tender, and it worries me that I don't see on the record, maybe I missed it, what the counter offer of your client was to the offer that was then made immediately after the order of eviction was made. Mr. Grobler's legal representative made an offer. I'm not saying that it was a perfect offer or that it should have been accepted. But the point is, it was an offer.
Yes.
Does that matter at all? Because by the time that the matter then went to the High Court, that offer had already been made already in the magistrate's court. And we know what happens in litigation. People litigate themselves to death. And
Yes.
then in the end, offers are made and matters are settled through engagement between the parties. I don't see that kind of engagement here.
Yes. May I just point out what that offer was?
We've seen it. We've seen it in the papers. And saying, I'm not necessarily saying that it should have been acceptable, but I don't see a counter offer. And at that stage, your client was legally represented.
Yeah, but with respect, this is not an offer of alternative accommodation. This is an offer made for the purpose of Section 4.8, because Mr. Grobler wanted Ms. Phillips out of there as quickly as possible. That's the only purpose of this offer. This offer says he's prepared that she can stay there for 2 more months. And after that, he will pay for her reasonable costs of accommodation for 1 year, as long as those costs don't exceed 4,000 Rand per month. So he was just looking to get her out of there as quickly as possible. This offer was made purely in the context of the Section 4.8 inquiry. It has nothing to do with the Section 4.7 consideration. This was not a permanent offer of accommodation at all. This was simply saying, get out of here as quickly as possible because I'll pay for you to live somewhere else for 12 months. That, with respect, is not the kind of alternative accommodation that one can even consider for the purpose of Section 4.7. It was made after the Section 4.7 order. It's not an offer of alternative accommodation. It's simply an offer of, I will pay for you to go and live somewhere for 12 months after you vacate within 2 months. So it's in fact quite an extreme position. The magistrate, in fact, gave Ms. Phillips considerably longer period than just 2 months. So this offer, so-called, which was entirely in Mr. Grobler's interest, didn't succeed. It was not in Ms. Phillips' interest at all, that offer. So my submission is there was nothing before the High Court at all in regard to alternative accommodation. Might I just also make one point? It's a changing tides point. In paragraph 18 of Changing Tides, the SCA, and this is a judgment that's been referred to a number of times by this court.
Before you move to that point, Mr. Fagan, I am not sure that we should attach the significance that you seem to attach to the reference to 10 days in the letter of offer. In context, should the reference to 10 days not be read to mean if after 10 days you have not accepted the offer, then I'm evicting you? It does not mean that Mr. Grobler is saying, and I will never ever listen to you again should you want to take me up on the offer. Is what I'm positing to you not a possible reading of that as well?
Possibly, but with respect, the point remains that in weighing up the considerations at the time of the magistrate's court proceedings, there was no offer extant at that time. In other words, there was no tender that the court could take into account. When the court evicted Ms. Phillips, then subject only to the period which the court then decided under 4.8, she would have to leave, and there was no alternative accommodation.
But you see, my problem is Ms. Phillips and indeed her lawyers at the time were aware that an offer had been made at some point. It seems to be self-serving for her to now behave as if there never ever was an offer and to just say there is no tender. Fine, there may be no tender at that stage, but the offer had been made, and she and her lawyers are aware of that. It seems self-serving for an attitude to be adopted that there is no tender.
But there's no tender for the purposes of weighing consideration.
That may be so, but they are aware of it.
Yes.
They are aware of it. How can they behave as if no offer was ever made?
I'm not sure whether anyone behaved in that way with respect to us.
No, based on your submissions, submissions. That is exactly what your submission suggests.
No, sorry, my submission is only this, that at the time that the magistrate's court had to make a decision, it was not a relevant consideration because the magistrate, and the magistrate doesn't do this, the magistrate doesn't weigh it up, doesn't say there's alternative accommodation offered correctly, because there was no extant tender then. So sure, one can say, well, Ms. Phillips should have negotiated or something, but with respect, Ms. Phillips had a certain position that she adopted. Her position was, I'm entitled to stay where I am. I've been here since 1947. I have an unregistered habitatio. This is my home. She's entitled to adopt that position. Anyone in litigation is entitled to adopt that position.
That's something else altogether. And it's not the same thing as to suggest that to want us to proceed on somewhat of a basis that no offer was ever made. An offer was made and it was rejected outright. And and reference is made, I think, in the replying affidavit to the fact that her sons were even insisting that she must be built a 2 million rand house. So this throughout has been a stance, and is the applicant, is Mr. Grobler forever and ever expected with, I still offer. They are aware that he did offer, and what are they doing about that? They wanted 2 million to be built a 2 million rand house. So it's not even as if it's a case of them being married to this particular structure. So they were prepared to move, but to move to a 2 million rand house. Let me just see if I can quickly find that in the paper. Yes, page volume 1, page 61.
Yes.
Paragraph 10.2. Ek het eerste respondent al laas jaar genader om die situasie van haar occupasie uit te klaar. Van haar kinders, skoonkinders en 'n verteenwoordiger van die ANC was teenwoordig. Haar seuns het buitensporige eise gemaak, soos dat ek byvoorbeeld vir haar 'n huis moet koop van 2 miljoen rand binne kompleks waarvan ek 14611 deel uitmaak. I won't translate it. It says what I said earlier about the sons insisting that I said to be built, rather that a house be bought within the same complex for 2 million rand.
Yeah.
So the offer had been there. Is Mr. Grobler every day? I offer. They are aware that he had made an offer. That's the point I'm trying to make.
Yes, and with respect, I haven't tried to suggest to the court at all that no offer was made. Of course, an offer was made and on a number of occasions before the litigation. But firstly, the reason she was entitled not to accept the offer, that's her entitlement, that's her right. In other words, she's entitled to say, well, firstly, her belief was wrong, but it was her genuine belief that she owned this property. She was trying to buy it from her. So leaving that aside, that's the one factor. But then the more important factor is that she's entitled to say, I'm going to litigate this. I don't want to accept your offer. And she doesn't accept the offer. But then when it comes to weighing up the considerations under section 4.7, then with great respect, it would not have been appropriate for the court to take account of merely of the fact that an offer had been made, which was not before it then, because the court is now considering, should I evict Ms. Phillips today or not? And on the day that that eviction order is made, she's out on the street, simply, because at that time there's no offer. And that, with respect, means
that's because of how she has chosen to litigate. That's because of how she has chosen to litigate. I'm not, of course, suggesting that the magistrate should not have exercised a discretion in terms of section 4.7. I'm not suggesting that. But the point I'm making is in response to the last point you are making. She finds herself in that situation exactly because of how she has chosen to litigate, and not because of any fault on Mr. Grobler's part.
Except for this, Justice Matlanga, it's how both parties chose to litigate. Mr. Grobler chose not to tender. Now that's a big decision. And he's a lawyer himself. He can't even hide behind the fact, but he also had lawyers acting for him. He made no tender in the magistrate's court. Now that's a very big decision for an applicant. He went into this case also as a litigant on an all or nothing basis. I'm going to win or I'm going to lose. If I win, she's out. So both parties, with respect, that offer just fell away, as it were. And Mr. Grobler did not tender it. And then very belatedly, he tendered it. And that's where we are now. I want to just make the point about changing tides, if I may, on alternative accommodation. In paragraph 18 of that judgment, the SCA spoke about the party seeking the eviction of a private person, where the party seeking the eviction is a private person or entity. There's no obligation under the Constitution to provide housing. They're not obliged to provide free housing, as this court has said, for other members of the community indefinitely, but their right to occupation may be restricted. They can be expected to submit to some delay in exercising or some suspension of their right to possession of their property in order to accommodate the immediate needs of the occupiers. That approach makes it difficult to see on what basis the availability of alternative land or accommodation bears on the question whether an eviction order should be granted, as opposed to the date of eviction, i.e. the Section 4.8 inquiry, and the condition attached to such an order. One can readily appreciate that the date of eviction will be more immediate if alternative accommodation is available, and that's the context in which Mr. Grobler makes his offer in the magistrate's court. Either because the circumstances of occupiers are such that they can arrange such accommodation themselves, or because the local authorities in place appropriate emergency alternative accommodation. And then he speaks about that. So the court there said that it's not really a very significant factor to be taken into account even in weighing this up. And with respect, there's something I would submit is sensible about that, which is that you're considering factors regarding the existing accommodation of this person. Now, to hold it against Ms. Phillips, that she didn't want to go and live somewhere else, in circumstances which you've been living in this place forever, is with respect to impose quite a significant burden on an elderly, indigent, illiterate
Mr. Fagan,
Yes.
Fagan, is this case about allowing Ms. Phillips to leave, as I put to Mr. Foss, until she meets her maker?
Yes.
In other words, indefinitely? And if that were to be the case, contrast that with my brother presiding has put to you
Yes.
about them asking for a 2 million house. Then when you look at it, there is a clear contradiction in the wishes. She wishes to live permanently, but she can leave if there is an incentive to buy a house in a gated complex. That doesn't make sense.
With respect, it may well because she might have thought, well, she can get something better, but she doesn't want to leave her house for something worse, for example. That with respect is a matter of personal decision rather than legal principle. Might I just raise the third significant unique factor that I submit would weigh with this court or has weighed with the other courts. For all the applicant knew, Ms. Phillips had a life right in respect of this property capable of being asserted against the world. In other words, for all he knew, she had a real right. She could have acquired such a right by simple registration. She could, for that matter, have had a lease at a nominal rental that endured for 15 years and huur gaat voorkoop, so that would have been enforceable against Mr. Grobler. He never investigated any of this. He chose not to investigate. Mr. Grobler took a chance when he bought. He knew there was someone living on the property. He decided willfully to remain ignorant as to the legal basis on which he was there. And it may have turned out that the title deeds protected her right. So Mr. Grobler, with respect, cannot now complain to the court that he's been expropriated by the SCA. That's precisely the chance he took. that he bought this property, and these are also the conditions of the auction sale, subject to occupancies, to existing occupancy. Any research that had to be done into the property, he said part of the condition that's for the purchaser to do. If he chose not to do it, if he chose to remain willfully blind, then he can't now complain that Ms. Grobler is saying, but I had this habitatio. Sure, it's not registered, but I had it. Because if it had been registered, it would be in exactly the same position. Mr. Grobler's position was one of buying blind. He was happy to do that. Well, then he must be happy with respect to take these consequences. This is one of the consequences, is that Section 4(7) gives protection potentially to someone like her. He was willing to take these consequences when he bought. He spoke to her for the first time on his own evidence after. I know there's a dispute about that, but on his version, he didn't speak to her before he actually bid at the auction. And he did no research.
Mr. Fagan, the 45 minutes is up. How much more time do you want?
I think if you'll give me one moment, just look at my notes, but I believe that I have covered the areas that I need to cover.
So you would end at this point?
I believe I've covered everything. So give me one more moment to look at my notes. Oh, yes, we've made submissions in paragraphs 50 to 52 of our heads regarding the nature of the discretion. That resonates with the question that Justice Unterhalter asked of our learned friend, Mr. Vos. If the magistrate exercised no judicial discretion at all, and the first judicial discretion was exercised was by the High Court on appeal to it, then the question arises whether it's appropriate for a court of appeal to interfere with the exercise of that discretion. There was clearly no misdirection by any of those courts of appeal, either the SCA or the High Court, and that has to do with the nature of the discretion. So if the discretion is in fact a strict one, and it's not always easy to know what the nature of discretion is, but our submission is that this meets the test for a strict discretion. That would be a reason not to.
Just for purposes of control, how much more time do you want?
No, that is my last submission. Thank you.
Oh, all right.
Thank you, Langa.
Just
I'm sorry.
Yes, my brother. Yes,
if
yes.
I may just indicate, I have a question, but whenever it's convenient.
Please go ahead. Please go ahead, my brother.
Mr. Fagan, I wonder if I could take you back to this question about the offers of alternative accommodation. In your heads, and I think in some measure in your submissions today, you've said that if there wasn't a proper offer on the table in the magistrate's court, it's in a sense too late to try and introduce it on appeal before the SCA. And I'd just like to ask you a question about that, because when one goes to the High Court judgment, much of the consideration there was concerned with Esther, and indeed a proposition that Ms. Phillips enjoyed a right of occupation. And there's a very meager treatment of justice and equitable considerations because it wasn't really necessary in the light of the other conclusions the court came to. So the first time that there is perhaps a very full consideration of what justice and equity might require in this case is curiously in the SCA.
Yes.
And given that rather unusual trajectory by which this matter proceeded to the SCA, and justice and equity wasn't considered in the magistrate's court, perfunctorily in the High Court, and only properly in the SCA.
Yes.
Given that this is remedial legislation where one tries to get to an equitable answer, why wasn't, at least in the circumstances of this case, why wasn't it proper to consider the offer and consider it not just as a matter of form, but as a matter of content when the SCA decided it was going to do a very full consideration of what justice and equity required?
Yeah.
It's just last comment, and then I'd be very keen to have your answer. Because justice and equity is such a broad and wide topic, where we try to achieve an outcome that is just and equitable, shouldn't we be encouraging offers of the kind that were made, even at an appellate stage, such as the SCA?
Yes, but with respect, whether that outweighs all the other factors, that's something this court will have to consider, of course. Indeed. The problem I think that the SCA was facing is because it was made so late. One of the difficulties that we have is if it had been made tender, if there'd been a tender in the magistrates court, there would be an opportunity for the evidence to explore this issue. What is suitable? Why isn't it suitable? Now the SCA simply has this offer made during argument on behalf of the appellant. It then says to the parties, essentially go and try and resolve this. See if you can't reach some kind of agreement. They can't, comes back to the court, and the court said, look, we gave them this opportunity, it didn't work out, and frankly, that's that. It's never been canvassed in evidence as it would have been if there'd been a tender in the magistrates court. That's the fundamental difficulty with this very, very late offer made when the shoe pinches, and of course, very different from the offer made under Section 4.8 in the magistrates court, a far more extensive offer, because the shoe was pinching, and that was obviously appreciated by Mr. Grobler. So you get this very late offer. There's no proper investigation. In other words, no court has facts before it. The court then is presented in argument here with an order that Mr. Grobler says he would be happy for the court to make. That's in paragraph 135 of the heads of argument. But it has things like the applicant is directed to purchase a 2-bedroom dwelling in a good condition. What a good condition means, what does that mean? The new dwelling shall comply with the following requirements. And there's the radius from the existing house plus the kind of rooms it must have. Can it be on the 3rd floor of a block of flats which has no lift, for instance? There's simply no proper investigation. An area with a house within 5 kilometers of the existing thing could take you into any number of Somerset West areas, some more salubrious than others. There's been nothing here. It's simply, with respect, unsatisfactory to put this up at such a late stage and ask a court, the apex court, in an appeal to it, to now have to make decisions directing someone to buy a house. What house? We just don't know. It was never canvassed. It's too late with respect practically to deal with this. And the approach of the SCA to this very belated offer that was made there in our respectful submission was entirely appropriate.
Yes, thank you.
Mr. Fagan, I just want to understand your argument about an offer that should have been made at the magistrates court. At page 510 of the judgment of the magistrates court, she says it is common cause that the offers for alternative accommodation was refused by the first applicant particularly. Whether it was refused of her own accord or whether it was refused of the advisors of her closest family, it is not very clear. But it is common cause that there was a refusal to accept any kind of alternative accommodation.
Yes.
What are you suggesting? Are you suggesting that some offer should have been made, or what? At what stage now, if the magistrate was told about the rejection of the offers?
Yes, it was on the papers. In other words, there was no question about that these offers had been made prior to, but those offers were not tendered. They were not repeatable over tender in the magistrate's court. The magistrate was aware of these offers, but that is all. And then she goes on in her judgment to deal with the basis for why there should be an eviction. As I say, it was a purely legal finding. That's because she had no legal right. She had no real right of habitatio, therefore she must be evicted. So it didn't weigh therefore as a factor with the magistrate, but she does record correctly. This is part of the history of the matter.
And your argument now, because the offer was now eventually made before the SCA, it is quite late. And So what is supposed to be, are you suggesting then that Mr. Grobler should go back to the magistrate's court and start the process all over again? Or what?
I wish to make no suggestions as to how Mr. Grobler should conduct his future affairs should this case go against him. I don't want to give him any ideas, but with respect to the question before this court is only, firstly, is it appropriate for this court now to weigh this at all? And secondly, if it is appropriate for this court to weigh it in its consideration, how heavily does it weigh, given all the factors? And the fact that it's such a very late offer, in our respectful submission, is relevant because it means that the High Court did not have it before it.
And now your argument, I'm reading at your para 48 of your submissions. You say that it is not, your submission is that whether or not there is an offer of alternative accommodation, she should not be evicted. So in other words, we should not have any regard to that offer of alternative accommodation.
With respect, those are two different submissions. In other words, one submission is this very belated nature of this an unsatisfactory way in which a tender was made is a reason to ignore it completely. But alternatively, if the court feels that it is a factor that should be taken into account, our submission is it should not outweigh all the other factors. And one consideration in that regard is precisely the very late nature of it and the fact that it's this very unclear situation that now pertains. So that those be our submissions.
Thank you, Justice Madlanga.
Mr. Fagan, just a small part from me on this debate that my colleagues have had with you. Is it your submission that the offer countenanced in the heads of argument of the applicant does not take care of the mischief that the PI Act was enacted to prevent?
Well, Section 4.7 specifically just vests in the court's judicial discretion. Yes. So it certainly must, on my alternative submission that I made a moment ago, it would be a factor that weighs with the court. So on that alternative basis, it's not ignored. But as for the mischief, yes, she's being evicted from her home. It's an unusual situation. She's been in this house since 1947. It's her home. I don't wish to quote as important authority that wonderful Australian film, The Castle, but in The Castle, this very point was made. It's not a house, it's a home. It's where she raised her children. It means everything to her. It's where she lived with her husband. And so it's not simply a technical matter of, well, we can swap it for something else. There are these significant considerations that, in my respectful submission, will weigh with this court. Of course, this court will consider all of these. It's a basket of factors.
Is it not important to consider the fact that she will not be homeless?
Yes.
Because that's one of the biggest mischiefs that the PI Act was enacted to prevent, and that it would not be an unlawful eviction.
Yes.
And those weighty considerations.
Yes. I will again make the point that she would have been homeless if the magistrate's court order had simply been given effect to. And she would have been homeless if the High Court had upheld the magistrate's decision. She would not be homeless if effect is given to this. No, she will not be homeless.
We are here. The SCA went out of its way to ask for this offer. It was made. It's unclear to me, well, I'll say you don't have to address it, but it's unclear to me on what basis it was rejected by your client. But we are here, and it's before us, unless you're suggesting that we should ignore it. But it's here, it's before us.
Yes.
I think that's why I'm putting these things to you.
Yes. And of course, it would be a factor that she will not be homeless, but again, it's one factor. It's alternative accommodation is only one factor. That's what Section 4.7 says. The legislature, in enacting the Section 26 legislation, or Section 26 of the Constitution legislation, saw fit to say the court must consider all relevant factors. And this is only one.
Okay.
And that's why I'm saying this court will, of course, weigh it up and will, of course, do the balancing act that one expects if this court should find that it's appropriate for it to do this again after the High Court had already done it, or the SCA for that matter already done it. If the court finds that, then this court will perform precisely that exercise. But the one consideration with respect does not trump all the others, and the others are weighty and unique.
Thank you. Thank you, Justice Madlanga.
Can I follow up there, please, Justice Madlanga? Mr. Fagan, in the proceedings in this court, this application, in the founding affidavit in which he seeks leave to appeal, Mr. Grobler says at page 812 of volume 9, the last volume, he says at paragraph 54, at the hearing of the appeal, the SCA requested the parties to engage with one another about the offer for alternative accommodation. And Mrs. Phillips was asked, presumably by the court, to consider the offer. Is that a true reflection of what happened?
Yes, it wasn't mero motu on the part of the SCA, but other than that, yes. Now that it was raised in argument, the offer was made or suggested in argument. Yes. And
then that list of properties that we see in the papers, that was sent to Mrs. Phillips to consider after the SCA hearing.
Indeed.
Now she didn't take the trouble of viewing 8 of the 11, as far as I can recall. She only viewed 3. Why was that?
I'm afraid I had no involvement in that process at all, Justice Majid. I'm afraid I can't assist at all. Beyond what's on the papers, I know nothing.
I accept that. Now, what troubles me is this. In the face of the SCA asking the parties for this engagement post the hearing, and that list being sent to Mrs. Phillips, and she only views 3 of them, the SCA deals with it at page 795 and onwards of his judgment in volume 8. 795 from paragraph 54 onwards. It sets out the affidavits were filed, and then it says at 56, this was read earlier in this hearing already, and I'll just paraphrase it. The court accepts that this offer was made in good faith and in recognition of the obviously adverse effects that ejectment of the first respondent bring about. It does not consider that it tilts the scales. Now, it seems a strange thing to say that it was made in good faith in the recognition of the obviously adverse effects that ejectment would have, considering that the SCA itself asked for this engagement. But this is what troubles me. Paragraph 57, can you please explain it to me? This was not a case in which the reasonableness or otherwise of an unlawful occupier's refusal to vacate was a central issue. The question arose tangentially and belatedly.
Yes.
Now, tangentially, as I understand it, my limited English means a peripheral issue. Was it a peripheral issue? I didn't read the case for it to have been a peripheral issue in the Madge Court or in the High Court or in the SCA.
Alternative accommodation certainly wasn't an issue at all with respect in the High Court.
Yes, but the question of refusal to vacate.
Oh, but I think, sorry, I understood this to be in context that the court, the question that arose tangentially and belatedly had to do with the reasonableness to refuse to vacate given the fact that there was alternative accommodation offered. I may be wrong, but that was my understanding of what the court had in mind when it said that. And I think in our heads of argument, we also quoted this sentence on that understanding. But we may be wrong because we're just reading another judgment, but that was our understanding of it.
Well, then finally on that score, and my last question is this. It ties in with what my brother Unterhalter asked you. This court's primary function in the Constitution is to see that justice is done. Would it be proper in the interest of justice to turn a blind eye to these offers that have preceded the litigation, rejected for whatever reason, to the offer made during the Section 4 sub 8 proceedings in the Madge Court, and the offer made in the SCA, when one is dealing with legislation which is aimed at providing a remedy for evictions and to ensure that it is just and equitable? Can it be in the interest of justice to submit to this court that they must turn a blind eye to all these offers, Mr. Fagan?
The one that I would certainly submit to the court, it should turn a blind eye to, is a Section 4.8 offer. That was entirely a different thing. That wasn't an offer of, that was just a way to get her out quickly. So that one I would submit yes. For the rest, certainly, I would submit to the court that it can take it into account. I've given my submissions already, as the primary submission being no, it shouldn't, because it wasn't before the courts, it wasn't a tender made. But in the alternative, yes, it must be taken into account, but so must be taken into account all the other factors that make this a unique case. There's no principle here that will be established about people being able to stay on other people's properties, given that these are very unique factors. In fact, I think it may also be in the Changing Tides case, where the SCA makes the point, which I'm sure this court would embrace and probably has said itself as well, which is that these cases are so unique on the facts that they're not really, it's not really helpful even to refer to other judgments, generally speaking, in regard to them, because each case must be decided on its unique facts. And the facts of this case are unique. They're truly quite extraordinary. Ms. Phillips, it's Ms. Phillips's ignorance that will cause her to be evicted, because anybody with a modicum of education or literacy would have known that you can protect your rights, or would have gone to a lawyer and protected those rights. And it's just that. It's such a small thing. If she'd just known to go to the Stellenbosch Law Clinic earlier and said, what can I do about this right? But she thought she had this lifelong right. She was happy because she'd been told she has this lifelong right. If she'd only just registered it, everything for her would have worked out fine. So the eviction, with respect, if it were ordered, is punishing her for her ignorance. And that's a very significant factor, and it's a very severe result. And justice, which of course Justice Majid, you're correct, that is the interest of justice, I would submit in this case, strongly militate against ordering the eviction of this octogenarian. It's not unlimited time. She's only going to be there with respect until she dies. And that's all that she's asking for.
Thank you, Thank you, Justice McLean.
Mr. Fagan, I understand the importance, even the emotion attaching to place, the connection to the home. I understand that it is the same with me, and I'm sure with most of us. If tomorrow my rural home, where I was born and raised, were suddenly not to be home for me, that would hurt me. So I understand that, and I appreciate it. But I want to raise this point. On your understanding, how absolute was it for Ms. Phillips that she just cannot move? How absolute was that?
No, I've got no indication. There's nothing on the papers to suggest that it's impossible for her to move. And so I won't make such a submission.
I just wanted to make sure, because you will recall earlier I did refer to the replying affidavit. I don't know whether it was you arguing or whether it was Mr. Force, where the reply, it was with you, yeah. The replying affidavit indicates that she was prepared to move as long as it was a 2 million rand house. All right, so that takes care of that. So it's not as if it was absolute that she would never ever move. All right, I'll move on to another point. I'm not sure how we are expected realistically to deal with the right of occupation, the habitatio. Is Ms. Phillips' case that because the right was not registered for all the reasons that she gives, we should then treat this right exactly the same way we would registered right, or what exactly is the position?
No, with respect, if it had been a registered right, then it would have been a simple answer. She would have had a legal defense, which doesn't require her to rely on section 4.7 of PI.
So it's
we
it's
invoke
more.
section-
No, it's exactly because it is not. That is why I'm asking. That is why I'm asking. But is she nonetheless saying we should treat it that way, or is it more that that it is factually quite akin to a registered right? It should be a weighty factor under the section 4.7 factors on a just and equitable remedy.
Yes, with respect, it's a very weighty factor because she could simply have registered it. It's a tragedy. It's literally a tragedy. If she'd only known to register it, there's no case. Mr. Grobler has no case, and she didn't register it because she didn't know that she should. That's all.
Okay, all right, no higher than that. Thank you very much, Mr. Fagan. Colleague? Oh, it seems there are no further questions from my colleagues. Thank you very much, Mr. Fagan. Yes, Mr. Foss?
As the court pleases, if I may deal with the submission about the time when the offer was made, firstly. And the first submission that I wish to make in that regard is to refer to playtime. The court will remember in 2017 that the offer of suitable accommodation was made a few days before the hearing on 27 February 2017. And that offer was made by the city. The offer was for land at Wolwerivier, some 30 kilometers from Atlantis. In that matter, the offer of alternative accommodation was made at a late stage, but the court accepted it and granted the order of eviction. In this particular matter, the conduct of Mr. Grobler has been clear. His whole intention has been to engage with Ms. Phillips and to find an outcome that would be beneficial to both parties. It's common cause that he met with her 3 times in person before the litigation commenced. It's common cause that he sent Mr. Esop, his attorney, on the 30th of April 2009 to Ms. Phillips to engage with her, to make the offer of alternative accommodation, to say, please speak to us. We want to resolve your situation. Subsequent to that, the offers were made in writing. Those offers were made in writing on the basis that please speak to us. We offer this to you. But if you don't revert to us within 10 days, you're leaving us no alternative but to commence with the proceedings. If at that stage, Ms. Phillips had come to Mr. Grobler and said, I want to talk to you about alternative accommodation, this matter would never have gone to court. It would have been resolved years ago. But unfortunately, the true reason for not engaging with my client is that there is a lack of bona fides. And the lack of bona fides is evident if one has regard to what the papers say. The papers say she will move if we buy and give her a house of 2 million rand. She doesn't raise any issue about security or dignity or difficulty to move because she's attached to the house. That is not raised in the papers at all. The affidavit in the magistrate's court also makes it clear that even while the litigation was proceeding, the attorneys for Mr. Grobler engaged with the legal representatives of Ms. Phillips and said, please settle this matter with us. Their whole attitude was, we are open to talk to you. Whether you call the offer an offer or whether one calls the offer a tender, not much turns on that. One should have regard to the conduct and the approach of Mr. Grobler. His conduct has been with respect to infuse passion and grace into the circumstances of Ms. Phillips. The proposed order in the SCA and the proposed order before this honorable court infuses elements of passion and grace in the life of Ms. Phillips. It is not a true order of eviction that is being sought. it is an order of relocation that is being sought. She will not be rendered homeless. She will not suffer any impairment to her dignity. She will be close to her children. She will still be in Somerset West, close to the Mediclinic, close to the shops. There will be no material change in her life. And then just lastly, as Clay Tyler said, in matters of this nature, there should be a give on both sides. There is no give by Mrs. Phillips. She refuses point blank to even have a look at the properties that we offered. 11 properties are offered. She looks at 3. She refuses to look at 8. How can one engage with somebody under those circumstances? It's just impossible. Those are my submissions as the court pleases.
Thank you, Mr. Forst. Thank you to both counsel. Judgment is reserved.
As the court pleases.
Today's proceedings have concluded. The host will now terminate the meeting.